Hi, YouTube. This is educational content. We will be reviewing a true crime case. Please note that we are reading a criminal indictment. We are not promoting any kind of behavior, just reviewing a criminal indictment for educational purposes. Again, this is educational content, and we are reviewing a true crime case. Let's go. You guys, welcome back to my channel, Down the Rabbit Hole News. I am the Rabbit. So I want to talk a little bit about the amicus curiae forms and documents that have been submitted to the Supreme Court of New Mexico for the Alexee Trevizo. These are very important documents that I think should be reviewed in preparation for the next hearing, which is approaching very soon, the first week of September. So I thought it would be important to do a video pre-recorded where I read these documents. I'm not going to be on camera because y'all can see I'm sick. So I am going to have like a visual playing and the documents so we can review them together. But I'm giving you guys my commentary and my opinion. I am no legal expert. I am just giving my opinion as it pertains to these documents. Of course, let me know what you guys think. Now, the first document was written by a professor who teaches law in California. Okay, but she has the backing of various entities. So these entities are in support of suppressing Alexee Trevizo's evidence, specifically video evidence. These are experts in the field of law, gynecology, police accountability, and civil liberties. None of these individuals are party to the case, and the Supreme Court permits individuals to submit these amicus curiae documents to give the court perspective and information. So one thing that I'm going to ask you guys to do is, separate your feelings from the case and let's stick to the facts, right? It's very hard to do, but I think that, it'll give us an opportunity to have a fluid conversation in the chat. Okay? Let me know what you guys think in the comments. Also, this video is a good over 45 minutes long. There's another document that I want to review that was also submitted to the court by like the American gynecologist or some gynecology entity. I've just seen how this video turns out to determine whether I'm going to spend another hour on another video separate. Let me know what you guys think in the comments, and I'll see you guys in the chat. Bye, guys. Professor G. Seon Song, the American Civil Liberties Union of New Mexico, that would be the ACLU, and the National Police Accountability Project respectfully submits this brief as a amici curiae in support of defendant appellee Alexee Trevizo. Ji Seon Song is an assistant professor at the University of California, Irvine School of Law, where she teaches and writes about criminal law and criminal procedure. Professor Song's research focuses on the complex intersection of criminal justice system and the healthcare system. Her article, Police in the Emergency Room, provides a groundbreaking examination of the way in which police are a routine presence in the emergency departments and how they impact the constitutional rights of patients. Her scholarship examines the interaction of different legal, regulatory, and ethical regimens when policing and healthcare meet. Professor Song has also co authored several medical journal articles with medical professionals examining the legal and ethical implications of law enforcement presence in emergency departments. Okay, so on the footnote, and this should be footnote number 1, is that Professor Song authors and files this brief on behalf of amici curiae. No counsel for any party authored this brief in whole or in part. No counsel, no or party made a monetary contribution intended to fund the preparation or submission of this brief. Important thing to note, to figure out if the professor, the ACLU advocate is being paid for this. She's somebody who's submitting an opinion about the Alexee Trevizo case and just the experience that she has with policing and the emergency room. Let's keep going. The ACLU of New Mexico is a nonprofit, non-partisan organization dedicated to upholding individuals' civil rights, civil liberties, and principles of equality and liberty. The ACLU of New Mexico's interest in the case stems from its deep commitment to rights of the individual to access confidential medical care without the interference of law enforcement. The National Police Accountability Project, the NPAP. The NPAP was founded in 1999 by members of the National Lawyers Guild to address law enforcement conduct by coordinating and assisting civil rights lawyers. The NPAP has an interest in the outcome of this matter because it is a legal membership organization that focuses specifically on the intersections of civil rights and misconduct of law enforcement and is uniquely involved in the protection of the human and civil rights of individuals in their encounters with law enforcement. The brief of amici curiae will assist the court by providing a comprehensive and nuanced understanding of how health privacy laws and medical ethics intersect with criminal procedure and policing practices, especially within the healthcare settings. It underscores the importance of maintaining clear boundaries between the roles of healthcare providers and law enforcement, highlighting that these roles serve fundamentally different and often conflicting purposes. This brief will support the court in evaluating the legality of police actions in medical settings, such as the emergency department in this case, where legal, regulatory, and ethical frameworks converge by clarifying the point at which healthcare providers' involvement crosses from medical care into law enforcement. The brief shows that health privacy laws, medical ethics, and criminal procedure principles support the trial court's decision to suppress Ms. Treviso's statements. This distinction is essential to protecting individual rights and upholding public trust in the medical system. So they're giving us a summary of these arguments. When police investigate patients in healthcare settings, medical providers must navigate their duties to public safety and to their patients amidst a complex array of legal and ethical obligations. Similarly, when assessing the lawfulness of police actions in healthcare settings like the emergency department, courts must reconcile a diverse legal and ethical landscape. Amici argues that the interests of police investigations do not vitiate the privacy rights of patients seeking medical care. The divergent purposes, laws, and ethics governing policing and healthcare, and the need to prevent patients from experiencing potential policing harms require the careful parsing of roles between law enforcement and medical providers. When faced with issues involving this intersection, courts must determine the point at which medical providers are no longer providing care, but instead are acting as law enforcement proxies, and if such actions violate patients' rights. So, this is interesting because I remember that Alexee Trevizo's attorney was making this very argument about her not being able to leave or her not being like everything that she's saying in that bed essentially was taken down as like her confessing to something. Okay. So keep that in mind. I think that this is a pretty interesting argument that this professor is making. The trial court correctly determined the proper boundaries between law enforcement investigative work and the provision of healthcare in finding that Dr. Vasquez crossed the line from medical provider to law enforcement agent when Ms. Trevizo made the statement at issue. Dr. Vasquez, highlighting that as we're speaking, is the lady who had the conversation. And I'm gonna play the clip of Dr. Vasquez. She actually had the interrogation and she gave her thoughts. I believe her interview with law enforcement was on Zoom. So she gave her perspective. She was the woman who was walking back and forth, checking on Lexi at the hospital, but she also walked back with Lexi to the room. So the question then becomes, when did Dr. Vasquez cross the line from medical provider to law enforcement agent? When Trevizo made the statements at issue. Okay, let's listen to the argument that they're making. Argument. Police and emergency department medical providers perform vital functions in our society. For the most part, these two professional groups conduct their work separate and apart from one another. But in the emergency department, these actors overlap, creating the potential for tension and conflict between the work of criminal investigation and the provision of medical care, and harm to patients from the overreach of police authorities. They give us a footnote defining the term emergency department is primarily used in this brief as it is the term used by the healthcare profession. Emergency room is the colloquial term referred to the same healthcare setting and is used in this brief when referencing a court case that employs that term. Okay. So they're giving us like an idea of what they mean by emergency department. To ensure that police and medical providers comply with their respective obligations to the public and the individual patient slash suspect, careful delineation of their respective roles is necessary. And this delineation is reflected in the statutory and ethical framework governing healthcare and in the criminal procedure doctrine. When lines are blurred between law enforcement and medical care by medical providers, however, the latter's actions are no longer within the realm of medical care, but instead fall under the province of law enforcement investigations. Their actions must then be scrutinized under the rubric of constitutional criminal procedure. Oh my goodness, that's a mouthful. So basically, when the lines are blurred between law enforcement and medical care by the medical provider. So if the medical provider is acting like a law enforcement agent, okay, they are no longer in the realm of a medical provider, but they are basically falling into a hole of law enforcement investigations. And so then that leads those actions from that medical provider to be scrutinized and then looked at as a constitutional criminal procedure, how they are violating maybe constitutional rights. If I'm understanding this correctly, oh my goodness, I mean, this is a mouthful, but that little paragraph right there is like, wow, okay. And if I have any medical providers or law enforcement agents, let me know, because in my last Alexee Trevizo video, some of you guys actually commented as medical providers. I was a little surprised, and you gave your 2 cents about the situation. Some of you guys actually live in Artesia and gave your thoughts about this case. So let me know what you guys think as we're reviewing these documents, court documents written by professionals. Because police and medical providers fulfill different purposes and functions. Any overlap of policing and healthcare implicates important healthcare privacy laws and foundational principles of medical ethics. Because emergency departments treat people with unexpected and often serious illnesses and injuries, police will inevitably enter these healthcare settings. But even as their presence may be inevitable, police investigations disrupt the normal course of hospital business. Law enforcement actions, requests, and very presence are in tension with fundamental tenets of healthcare privacy, law, and medical ethics. The disruption is exacerbated when law enforcement's investigation breach constitutional protections. As seen in Ms. Trevizo's case, when these two groups become intertwined in the context of a medical health emergency, with police interrogations being conducted by health providers on medically vulnerable patients suffering from acute injuries, a medical provider's ability to provide the best care possible for patients is compromised. My goodness. Police officers and medical providers fulfill vital but diametrical opposed functions in society and are subject to different regulatory regimens. Police are tasked with protecting the public and investigating crimes. Emergency medical providers treat people who are injured or sick and require urgent attention. To put it in even starker terms, police are the only entity in our society legally authorized to use deadly force. Emergency medical providers are our society's healers. The diametrical opposed purpose of these entities mean that police work and healthcare work differ in many ways. In service of their purpose to protect public safety, police officers are charged with conducting investigations through searches, seizures, interrogations, and other forms of evidence gathering. Medical providers' primary job is to provide medical care to people. Police and medical providers are thus governed by different legal and ethical regimens. Okay, so let's time out right here. I would agree, right? Like there are different legal frameworks for police and medical providers. Actually, a lot of these professionals have different frameworks. They don't operate under the same scope. So, yes, this is correct. The ACLU, this professor, is basically setting the groundwork to let us know, like, this is like apples to oranges when it comes to legal framework, when it comes to the frameworks of the jobs that these two entities have to do. Let's keep going. Law enforcement officers operate under rules laid out in federal and state constitutional criminal procedure. A variety of state and local regulations and rules, and individual department polices. Okay, and so they're citing a source here. Police accountability typically comes in forms of exclusion of evidence in criminal cases or civil rights remedies for constitutional police actions. These remedies have been criticized as insufficient accountability measures because of doctrine like qualified immunity that shield bad law enforcement actors, and the fact that law enforcement misconduct does not always lead to criminal prosecutions, thereby avoiding judicial scrutiny. Medical providers are subject to a much greater scrutiny through an array of statute and regulations. Oh, okay. So here's the question in the chat that maybe you guys can answer. Who is subject to more scrutiny, law enforcement or medical providers? Okay, so this professor is saying that medical providers are subject to greater scrutiny through an array of statute and regulations. Medical providers must comply with federal and state health privacy laws. Okay, so they're quoting the HIPAA public law. In addition, medical providers must abide by the State Medical Practice Act and are subject to oversight by the medical board. Physicians and nurses are further regulated by standards of care and torts laws of medical malpractice and negligence. Ooh, okay, so I guess I see the point where it's like medical professionals are kind of held to a different standard than police officers. And, police officers may only govern certain aspects of a law. So only so much that applies to a police officer. But let me know what you guys think as I'm drinking my tea, because I don't know if you guys know I have a sore throat. In addition to these laws and regulations, medical practitioners are governed by professional ethics and norms. Newly minted doctors and nurses take versions of the age-old Hippocratic oath to uphold their obligations to patients. Key ethical principles include principles of non-maleficence, to do no harm, beneficence, acting in the best interest of patients, justice, fair and equitable treatment of patients, patient confidentiality, and patient autonomy. Okay. The American Medical Association, which is the AMA, is a key authority of medical ethics. It publishes numerous ethics opinions to help practitioners navigate their ethical obligation when faced with complex real-life scenarios. The New Mexico Medical Board and the state agency overseeing the medical professionals in New Mexico has adopted the ethical standard. An opinion is issued by the AMA. Police investigations in medical care raise important concerns about patient privacy and autonomy and create ethical conflict for medical professionals. Though it may not be inevitable and necessary that police come into the emergency department, police presence can disrupt important fundamental tenets of ethics, such as patient confidentiality, privacy, and autonomy. The preamble to the AMA Principles of Medical Ethics emphasizes that the duty of physicians is to the patients first and foremost, as well as to society. Okay? A physician must provide medical care with compassion and respect for human dignity and rights, respect the law, and safeguard patients' confidence and privacy within the constraints of the law. A physician shall, while caring for the patient, regard responsibility to the patient as paramount. Patient privacy, the code provides, is not just a value in and of itself, but a prerequisite to developing a relationship of trust with patients and a sign of respect for patient autonomy. Hence, when faced with a situation where physicians must balance the patient's privacy against other competing obligations, the physician must seek to protect patients' privacy in all settings to the greatest extent possible, which includes minimizing intrusion on privacy when the patient's privacy must be balanced against other factors. Oh my goodness. And this is so interesting that we're hearing this here because, you know, one of the things that I said, if they had taken a pregnancy test of Alexei and they knew the girl was pregnant and she was denying being pregnant, why didn't they figure out a way to get inside that bathroom or something, right? She didn't open the door. She didn't answer, the door for them when they were knocking. She was basically that's one of the charges is that she was tampering with evidence. She was essentially hiding evidence of a baby. We don't even know what happened to the what is it the placenta. People when this case was first let out, they were like, well, maybe she flushed it or maybe she did something to it. That was never answered, right? What did happen to that placenta? And I mean, what could the doctors have done if they're asking her questions about her treatment, but they can only go so far with her because she's not being honest. So when somebody's not being honest with you, how do you balance that in the scope of in the sense of privacy, especially when it involves the her giving birth? At some point that baby becomes independent of her, right? Like the minute that the child is born. So yeah, anyways, this is interesting that professor put this in here because I think that's the question that we have is how do you balance this privacy in this intrusion, especially when you're trying to save another child's life or another person's life. Given these core ethical values and norms, police investigations in the emergency department produce profound ethical conflicts for medical providers. When healthcare work overlaps with law enforcement investigations, medical providers are faced with diametrical opposed obligations. The duty to keep patients' information confidential and the duty to inform law enforcement of patient information and the duty to not harm and the duty to report to police so they can uphold their job of protecting public safety. The most extreme yet routine scenario of law enforcement investigation in emergency department involves police requests to have medical providers conduct medical procedures with or without warrants to get evidence of a crime. These searches of the interior of the body are among the most intrusive searches law enforcement may conduct. Okay, so they're citing some cases here. I'm assuming it has to do with like searches and medical providers. So basically, here, and I'm going to read it, it's in the parentheses. Holding the warrant did not authorize a search of plaintiff's body that includes a rectal exam and x-ray by doctor, and thus the search violated plaintiff's Fourth Amendment right. These procedures intrude on a patient's autonomy when they are carried out by medical providers without patient's consent and when the procedures are not medically necessary or justified. In fact, when such circumstances arises, medical providers have been advised to adhere to their ethical standards to the best of their ability, including seeking consent from patients first when confronted with law enforcement investigative requests, and even refusing to carry out orders when physicians believe such actions would damage the patient's welfare and violate their rights. Okay, so that's interesting. See, this is the interesting part because it's like, well, what about the child? They're basically saying that medical providers have been advised to adhere to the ethical standards to the best of their abilities. including getting consent from the patient when confronted with law enforcement investigative requests, and even refusing to carry out orders when physicians believe. So, would the physician then be charged with intervening with an investigation? I guess that's the question. And when does HIPAA go out the door? Because I thought that if a crime occurred, that somehow HIPAA goes out the door, but I could be wrong. So, anyways, this is an interesting paragraph here, and they're quoting the American College of Emergency Physicians. Okay, it is not just intrusive procedures that raise ethical conflict. The presence of police in the emergency department gives police a broad access to confidential patient information, a fact that is especially concerning because police are not obligated under the law to keep medical information private. Huh. Okay. Police may listen in on patient interviews with providers, observe medical examinations, or simply be present in treatment areas. In all these situations, it is difficult or impossible for medical providers to maintain patient confidentiality and protect patient privacy. Oh, I didn't know this. So, law enforcement is not obligated under the law to keep medical information private. So this is why when this is a good part. The reason why people were able to FOIA those body cam footages is because police is not obligated to keep any of that confidential. But my question is, how did they get a hold of the hospital footage? Was it also through a FOIA? I don't know. This is a good question though. It further goes. Further, when, as here, police are able to interrogate patients who are suffering from acute injuries and medically vulnerable, the medical provider duty to provide care and do not harm to the patient is compromised. Okay, so basically saying that Alexee Trevizo's situation, she became compromised. Okay, so I'm highlighting because this is important, y'all. And there is a footnote, excuse me, there is a footnote on this. Police are generally not included in categories of entities who are subject to the state and federal health privacy provisions. Using the terminology of HIPAA, police are not covered entities like hospital physicians or nurses, and hence do not have to keep information they received in confidence except in unusual circumstances, such as when the police are part of the entity and that provides medical care. Okay, that's good to know. I mean, this is a very good to know. They're not obligated. Okay. The different purposes, functions, and governance structures underscores the importance of a careful deciphering of police and medical roles when police enter the emergency departments. The extension of problematic policing practice into the emergency department causes harm to patients. The presence of police in the emergency department causes issues beyond ethical conflicts. Indeed, police have caused direct harm to vulnerable patients who seek care in the emergency department in the name of public safety. The general problem with policing ranges from the targeting and surveillance of racial minorities to conducting unlawful arrests and searches to use of excessive and often deadly force. It further goes, these overboard and unlawful policing practices extended to hospitals and their emergency department, culminating in events that have reached the public's consciousness. Police have shot and killed patients. Okay. Yeah, I mean, that has happened. And there's research, of course. In New Mexico, police have arrested and brought individuals to hospital for invasive procedures conducted by medical providers only for no drug contraband to be found. Other less sensational yet equally pernicious examples of police overreaching include reports of medical personnel of police officers taking down names and birthdays of patients in treatment areas, even when they're not in police custody, and law enforcement installations of a license plate reader at the entrance of the emergency department without notifying hospital personnel. Okay, so in the Professor Ji Seon Song is quoting herself in this site. Okay, medical providers have also been on the receiving end of unlawful police conduct. Medical providers have been arrested for refusing to comply with what they perceive as unlawful police action. Well, and that's my question. It's like, if you're refusing to like comply with law enforcement, aren't you also couldn't you also be arrested for like, you know, upholding the medical ethics over a police investigation? Like, that's the thing that I'm wondering about that, because even in cases where law enforcement acted in concert with medical personnel input and are justified by ostensibly medical purposes, the combined force of medical personnel and police action upon patients in case have been found to be unlawful. Okay, a 2001 United States Supreme Court case is instructive here. In Ferguson versus City of Charleston, a nurse employed by a hospital in Charleston, South Carolina, began a program that drug tested pregnant patients in collaboration with law enforcement. Oh, so then what would happen? Well, if they tested positive, they probably arrested the pregnant women. The Supreme Court held that the program violated the Fourth Amendment right of the pregnant patients, as the program had a clear law enforcement purpose and the tests were conducted without patients' consent. Okay. Holding that the involuntary drug testing of women patient at a hospital violated the Fourth Amendment. Okay. Because of these because of such harms, emergency medical providers have mobilized, forming professional groups, publishing articles, and advocating within their hospitals and in the public for patient-centered approaches to law enforcement interaction. The vastly different purposes, functions, and governing frameworks of the two professions invariably lead to major ethical conflicts and tension when the two intersect. And the stakes are not just about ethics conundrums. Actual harm to patients can result when overboard and unlawful policing occurs in healthcare settings dedicated to healing medically vulnerable patients. Okay? Medical privacy and medical privacy laws and medical ethics delineate the distinctions between medical care and police investigations. Because of the different purposes, regulatory frameworks, ethical issues and the potential harm, it is especially important to delineate how and when medical providers should participate and cooperate in police investigations, particularly when the target of the police investigation is that the provider's name, such delineation exists under federal and New Mexico law, even when the law mandates the cooperation of medical providers, such as when they must report certain types of suspected crimes and injuries. Health privacy laws and ethics require that their involvement is time and substance limited. Moreover, the ethics must continue to guide medical providers even as they comply with their legal obligations. When the line is blurred, however, the medical provider exceeds the permissible scope of their legal obligation. The law provides a governing framework to determine whether those actions are lawful. That framework is constitutional criminal procedure. Okay, so then they give us a good example of a common collaboration here in this footnote. A common collaboration between medical providers and law enforcement occurs in SA cases. SA nurse examiners, which are called SANE, are a type of forensic medical personnel trained to question and examine victims of SA and to ensure that the evidence comports with chains of custody requirements. As described in the discussion on the Sixth Amendment, these programs are subject to rules that decipher the purpose of the work of SANE providers as law enforcement or medical care. Okay. Health privacy laws create distinct and discrete exceptions and procedures outlining when information relevant to criminal investigations is to be provided by healthcare providers to law enforcement. A person's medical privacy rights are not unlimited. Legislatures have deemed it necessary for health providers to disclose patient health information for societal interests, such as a collection of data relating to certain diseases in criminal investigations. These exceptions are delineated by statute in both federal and state law. They are not broad permits. Instead, they are circumscribed by regulation and authoritative ethical advisements. To properly understand the law enforcement exceptions to the privacy to patient privacy, it is necessary to start with the HIPAA Act, the federal statute governing the protection and disclosure of patients' health information. HIPAA is critical to the evaluation of the behavior of the medical providers in Ms. Trevizo's case. Okay, so they're going to use HIPAA to evaluate this. This should be interesting. HIPAA informs the extent of disclosures of patients' health information permitted by health privacy laws to law enforcement. And then they write a footnote here that says, in addition, even though HIPAA is a civil statute and any violations of HIPAA does not result in a remedy in criminal cases, its provisions are also relevant to questions in criminal cases because HIPAA contributes to our understanding of societal privacy exceptions. As both parties note, HIPAA provides instances when patient health information may be disclosed to parties. These exceptions include reports to public health authorities, and relevant to the instant case, information related to the potential criminal conduct. Three exceptions contained in HIPAA are potentially applicable to the instant case. The first exception, as the state notes, permits the disclosure of patient information relating to a crime that occurred on the premise of a covered entity. The provisions specifies that such disclosure may be made, as HIPAA exceptions are generally permissive in nature and not mandatory. The provisions also limits the information to be disclosed to protect health information that would alert law enforcement of the nature and commission of the crime, the location of the crime and victims, and the identity, description, and location of the alleged perpetrator of the crime. The second exception highlighted by the state BIC 37 falls outside of the delineated exceptions contained in 45 CFR and instead concerns the disclosure of patient health information of the victim of abuse, neglect, or domestic violence. This provision does not apply to Ms. Trevizo, who is the one suspected of the abuse or neglect here, and not the victim of it. The third exception allows disclosure authorized by the state law, including mandatory reporting statutes. Okay, and they list out the statute here authorizing disclosure required by law, including laws that require the reporting of certain types of wounds and other physical injuries. Hence, in addition to these federal provisions, to properly evaluate the conduct of the medical team and law enforcement in this case, we must look to New Mexico laws. Applicable New Mexico laws include its provision or physician patient privilege and confidentiality. New Mexico also follows other states in mandating that physicians and nurses report incidents where they have reason to suspect child abuse or neglect. In such instances, the statute provides that when a reporting party knows or has reasonable suspicion that a child has been abused or neglected, they shall report the matter immediately. New Mexico enacted this statute when nationwide attention was focused on increasing protections for vulnerable children. Historically, these kinds of abuses were hidden from view and not commonly reported to officials. Though the impositions of mandatory reporting obligations on medical providers are not without controversy, these professionals were not included as reporters because of their unique proximity to the victims and their ability to uncover suspected cases of child abuse and neglect. Okay, and there's a footnote here that says under 10, this provision of HIPAA regulation also differs from the general law enforcement exceptions to the HIPAA privacy rules in that it is designed to protect the victims of any abuse, neglect, or domestic violence. This provision should be read with, and then they put in the code there, which requires that the covered entity obtain the consent from the victim unless such consent cannot be obtained. The language of the statute reinforces its purpose to identify instances of child abuse and to ensure that no further harm is caused to the child. Once the report is made, the statute requires the recipient of the mandatory report to conduct the investigation, taking investigatory responsibility out of the hands of the reporting party. The recipient of a report shall take immediate steps to ensure prompt investigations of the report. The investigation shall ensure that immediate steps are taken to protect the health or welfare of the alleged abused or neglected child. The delineation exceptions to patient privacy and confidentiality do not authorize board and amorphous gathering and transmission of patient information to law enforcement. These statutorily delineated instances where medical providers assist and participate in criminal investigations are time and substance limited. Okay. At first blush, the new Mexico statute would seem to give law enforcement access to any and all patient information if the crime at issue concerns a child abuse or neglect. However, such a broad and amorphous permission would render inapplicable large swaths of health privacy laws and the medical provider's duties of confidentiality and privacy for any patient suspected of child abuse or neglect. Rather than adopt this broad reading that would make health privacy and patient confidentiality protections largely meaningless, a thorough and contextual analysis of medical providers' legal and ethical obligations points to the opposite conclusion, mainly that the exceptions to the disclosure provision in HIPAA and mandatory reporting obligations imposed by New Mexico do not result in the wholesale production of patient information and evisceration of patient confidentiality or privacy protection. Medical providers should not wholesale disclose information to law enforcement, but only information that is necessary for law enforcement to begin their investigations. Oh, okay. So I feel like what? So it says here medical providers should not disclose wholesale information. Oh my god, my highlighting is a little bit crazy. For law enforcement to be hold on. So medical providers should not disclose information to law enforcement, but only information necessary by law enforcement to begin their investigation. There's a dead child in a bin. What part were they not supposed to disclose? I guess I'm so confused by this. Okay. This contextualization, reconciliation of the applicable laws and ethics is not just correct. It reflects the balance of respective goals of public safety and patient rights. So what takes again, like what? This is an interesting little paragraph right here, but let me know what you guys think in the comments. In the instant case, by the time Ms. Trevizo made the statements at issue, the mandatory reporting to the police under New Mexico law had already been made. Okay. So the fact that they called police, that was already made. The police had arrived in responding to that reporting, the reading that best comports with New Mexico law and federal and state and health privacy laws and the ethical principles governing medical providers is that the mandatory reporting requirement ended at that point. Okay, so once they called police, that was it. There was nothing else. Okay. Mandatory reporting statutes are meant to help police identify when a crime has occurred and to give police relevant information that the medical provider is aware of at the time of the report. It is not meant to help police build an evidentiary case against the suspect. What? But okay, like, so report the crime. This takes me back to that one video where the nurse was talking to the officer and was saying like his statement. We went up there, she denied being pregnant, like, so what they wanted was just report the death of the child and then you're done. I'm so confused. Like, this is such a interesting paragraph right here, guys. This whole little area, which is what you guys are seeing me highlight.
Okay, I hope that they tell us a little bit more explanation to that paragraph on the next paragraph. How do we get to this conclusion? Here again, we begin with HIPAA. HIPAA provides a federal floor of patient privacy, depth of health and human services health. Okay, this means that states can be more protective of health privacy than HIPAA, not less. Okay, if any state provision conflicts with HIPAA and provides less protection, the state is preempted. Okay, so because of HIPAA laws, it basically allows medical professionals to not guide law enforcement or work with law enforcement. Okay. State mandatory reporting obligations are not preempted by HIPAA. But again, the analysis does not stop here, does not stop there. State mandatory reporting laws and the extent of disclosure by healthcare providers are limited to that required by law. So, and they give us a definition here of the law. A covered entity may use or disclose protective health information to the extent that such use of disclosure is required by law and the use of disclosure complies with and is limited to the relevant requirements of such law. Hence, though medical providers fulfill the reporting requirements as specified by law, the law in and of itself does not open the door for the release of any and all related patient information. The guidance from the AMA Code of Medical Ethics, adopted by the new Mexico Medical Board, comports this balancing of disclosure and maintaining patient privacy. The ethics opinion on patient confidentiality highlights the need for patients to be able to trust their physicians will protect information shared in confidence. Okay? So the confidentiality medical code. Here's an opinion. The opinion provides that general patients are entitled to decide whether and to whom their personal health information is disclosed, recognizing that patient consent is not required in all circumstances where physicians must disclose. The opinion continues to emphasize that providers should restrict disclosures to the minimum necessary information. The ethical guides the ethical guidance of minimum disclosure is consistent throughout the ethic opinions, including when medical providers become aware of medically at risk drivers. Okay, they're quoting more research. I'm going to try to go a little bit further. The American College of Physicians Ethics Manual provides similar advisements, affirming that reporting obligations are consistent with physicians' duty to protect public health. The manual also states that if breaching confidentiality is necessary, it should be done in a way that minimizes harm to the patient and heeds applicable federal and state laws. Yeah, but this doesn't really answer my question. Like, okay, so protect Alexee Trevizo's health. I get that. But what if she committed a crime? Like I'm so confused by this. So is the argument is that the medical staff didn't do enough to protect her health. Okay, her health information. All right. So why is this how does this trickle over to the criminal matter? Why wouldn't this be part of the civil matter, right? Like I guess I'm confused. Okay, it further goes. In the same way that mandatory reporting laws impose discrete obligations on medical providers, court's evaluation of physician patient privilege in conjunction with police investigations reveals similar delineations between the law enforcement and medical role. In State versus Roper, a police officer was in the emergency room to question a defendant for driving a vehicle while under the influence of alcohol. The officer then asked the treating nurse for the defendant's blood test results, and she disclosed that information. The court found that disclosing the results of a blood test constituted a privileged communication under CR SCRA and should not have been disclosed to the police officer. The court determination in Roper represents the exact kind of discernment necessary when determining the limits of policing in medical care situations. Okay, so she's making like an example, right? situation where there was a drunk driver, I guess. He was driving the car under the influence. Officer asked the nurse for the defendant's blood test, and the court was like, this is privileged communication, right? These are all HIPAA things. You can't just give out this kind of information. So the argument being made here is that this is the same kind of discernment necessary when the limits of policing in medical care situations. Like, you can only limit the information that you give to law enforcement. Okay, so what information? Okay, like, I'm just wondering in my mind, should the medical staff have called the police and said, hey, there's a dead baby, and that's it, and then have them do their investigation? There's a dead baby, and it's in, it was placed in the trash can. It was found there. It happened after, the baby was found after Alexee Trevizo came out of that bathroom. That's it? Was there anything else that should have been done? I guess I'm confused by this whole situation. What do you guys think in the comments? Let me know. And make sure you guys are hitting the like button, guys. I am a little sick. And so, we're doing this as best as I can. I'm trying to break it down as much as I can. I'm not a lawyer, but I did go to grad school, and I've worked in government for a couple years, for 10 plus years. So I kind of know the ins and outs of this stuff right here. Let's keep going. Law enforcement present in the emergency department is not a carte blanche authorization to obtain patient health information that would otherwise only be disclosed subject to specific procedures in criminal cases. Carte blanche means complete freedom to act as one wishes or best thinks. Okay, it's what is it called? It's Latin. So that's what that word is, okay? Indeed, it makes no sense that clear procedures for information gathering exist in criminal courts, such as warrant applications, subpoena, discovery processes, and court proceedings like in camera review for the proper adjudications of the release of private medical records, only to be sidestepped by conscripting medical providers into the criminal investigation process. Okay. Healthcare providers' disclosure and assistance beyond legal mandates transforms their role from healthcare providers to agent of law enforcement and opens the door to the violation of individual rights. All right, this is the paragraph that I have been waiting for to figure out are they making this argument here. Now I'm trying to highlight in a straight line, but I mean, it's just not working. So it is what it is. When healthcare providers go beyond legally authorized and mandated disclosures and exceptions to patient confidentiality, privacy provisions in cases involving law enforcement, they do not just run afoul of health privacy laws and ethical mandates. At that point, they are no longer providing medical care. Instead, they are providing direct assistance to police in the gathering of evidence through questioning and seizures of evidence. They become agents of law enforcement. In this case, as both parties agree, the report and identification of a potential crime incident was completed by the time Ms. Treviso made the statement at issue. These statements made by Ms. Treviso to Dr. Vasquez occurred after her examination, her labor and delivery, and after the police arrived. And I think they're referring to the statement of, I wish they would have put the statement there, but I'm pretty sure when Alexee said, I'll play the clip here, something to the effect of it wasn't breathing, or it wasn't moving, or it wasn't anything, something like that. When healthcare providers cross the line from providing treatment to participating in law enforcement investigations, constitutional criminal procedure is the governing framework for evaluating the lawfulness of the conduct vis-a-vis the individual rights of suspects. This division between medical purpose and law enforcement can be seen in various criminal procedure doctrines, from the Fourth Amendment search and seizure questions, the Fifth Amendment interrogation issues, and the Sixth Amendment confrontation clause and hearsay questions as adjudicated by New Mexico courts. For example, in cases assessing the applicability of the Fourth Amendment to force blood draws from criminal suspects or defendants, the constitutional question depends on if the directive came from a law enforcement actor or whether the blood draw was done for medical purposes only. Okay, so they're quoting a case, Gallegos versus Virini. The Court of Appeals determined that the defendant's Fourth Amendment rights were violated when the police officer directed medical personnel to draw the defendant's blood without a warrant or valid exigent circumstances. So, is it the fact that as soon as law enforcement came through to tend to the situation and investigate, medical staff started working with law enforcement by giving information, gathering statements, and so then they become the this is where the lines get blurred, where medical staff then becomes agents of law enforcement. Okay, let me keep going. The line between law enforcement and medical purposes is also clearly delineated when court determines the contours of a Fifth Amendment violation. This court decision in State versus Ibarra reflects this delineation in criminal procedure doctrine between actions taken for the purposes of medical care versus those in furtherance of police investigations. Okay, the court found that a nurse had conducted an interrogation of a defendant while he was in the hospital. The court distinguished its conclusions from the situation in State versus Gruelle, where the defendant made statements to an ambulance driver and physician were merely overheard by the nearby police officer. The delineation between law enforcement and medical purposes is relevant in cases addressing the Sixth Amendment question of the confrontation of witnesses. The most common scenario in which this issue arises involves statements made by patients to SA nurse examiners. The purposes of the interview is relevant to whether the statements may come in under the confrontation clause. The district court must be vigilant that a sane nurse dual role is not used by the prosecution to end run the confrontation clause by introducing statements made for a testimonial primary purpose under the guise of having been made for a medical care primary purpose. The analysis for determining the admissibility of hearsay evidence is also contextual, looking beyond the general purpose of the examination or question to the content of the questioning as the court determines. So they're citing a case. In either case, the inquiry is directed at whether statements were made for medical and or evidence gathering purposes. Okay, further goes a delineation between the work of law enforcement and emergency medical care serves our society goals of public health and public safety. Finally, a clear delineation of roles is necessary for public policy reasons. Emergency departments are vital to healthcare access and provision. Over the decades, they have become central to the delivery of healthcare in the United States. Emergency departments now provide for nearly half of hospital associated healthcare. Emergency departments have become the de facto and central provision of healthcare in the United States. They are society's safety net. The fundamental value of giving medical treatment to people with urgent needs is what led to the enactment of the federal law, the Emergency Medical Treatment and Labor Act, which prevents hospitals from denying or limiting health care to individuals based upon their financial or insurance status. Emergency Medical Treatment and Labor Act consolidated Omnibus Budget Reconciliation Act of 1985. Okay. The presence of police in treatment areas without hospital regulations and guidelines can lead to several negative social effects. Police present in hospitals has been shown to strain patient relationship with providers and erode their trust in the healthcare system. This mistrust is not just limited to the individual, but has also been found to impact families and communities. Making clear the distinction between police investigation and medical care in healthcare settings may seem to hamper law enforcement aims, but that interpretation is short sighted. The delineation of roles confirmed by judicial oversight ensures that law enforcement conduct their jobs lawfully and help them understand how to navigate a healthcare setting with privacy consideration that are very different from how privacy is understood in the context of constitutional criminal procedure. Furthermore, such delineation ensures that lawful gathering of evidence contributes to a criminal court process and is procedurally and constitutionally sound. Okay, so here we come to the conclusion. Okay. The harm to Ms. Treviso as a result of this ordeal and the public dissemination of her medical emergency cannot be undone. Moreover, the ramifications extend beyond Ms. Treviso to other vulnerable individuals who read her story. They may wonder how private are their encounters with medical professionals? Are medical providers in fact working hand in hand with police? Ooh, what do you guys think about this right here? The trial court could not turn back the clock to correct the missteps by the law enforcement officers and the healthcare providers the night Ms. Treviso entered the emergency department. But the trial court did what it was in its power and capability by imposing the consequence of suppression for the overreach of law enforcement and the medical team's shift from providing care to acting as law enforcement proxies, discerning the delineation of roles and imposing consequences when such delineation is transgressed is essential to upholding the law, ethics, and public policy concerns fundamental to protecting individuals and promoting public safety. By redressing the rights violation when lines were crossed, the trial court vindicated Mr. Treviso's rights and provided critical future guidance to police and healthcare providers who will continue to cross paths at this intersection. Okay, so then this is I struggle with this right here, but okay. So the trial court vindicated Mr. Treviso's rights and provide critical future guidance to police and healthcare providers who will continue to cross paths in that intersection. Okay, but what about the baby's rights? I'm so confused. The baby was born. Now I know that the defense team is going to argue whether it was born alive or dead. Like there's going to be this argument there, but baby was alive. The baby was breathing up until it wasn't when that bag was, you know, when that bag was placed over. So this is what the professor had to say. Now there is another document that we are going to read, but this video is already well over 45 minutes. If you guys want me to review the other document, which is I believe is the gynecologist's office and what they have to say about this whole situation, please let me know in the comments. Just let me know, read the gynecologist one, do a separate video, okay? I do apologize for not showing my face on this video. I am really sick, so I figured a read, as congested as I sound, would be okay. But make sure you guys are supporting the channel and hit the like button. All right, I'll see you guys on the next one. And again, let me know in the comments if you want me to read the gynecologist and what he had to say to the Supreme Court.